Welcome back. This is Key Point on TV3. We're live on 3FM 92.7, also on TV3 Ghana on Facebook, the DSTV channel 279, all across the world on 3news.com. Now, this week, the courts slapped 4 years and 6 months on Aisha Huang. The Deputy Attorney General, after that ruling, indicated that the office was satisfied, only for us to wake up the next day to a statement from the Attorney General himself indicating that, well, they are, yes, they congratulate the judge for showing so much commitment to having this case prosecuted within a 1 year, almost a 1 year period. But then again, he has concerns. This is what he said. While applauding the efficiency of the justice delivery system witnessed in the trial of Aisha Huang, the Attorney General will, however, test the soundness of the decision of the trial court to punish the accused person under Act 900, which is the old law, by filing an appeal at the Court of Appeal against the sentence in order to ensure that the new sentencing regime imposed on by Act 995 is applied to the accused person. And what that means is that if you're applying Act 995, all things being equal, if his appeal succeeds, Aisha Huang will be faced with between 15 years and 25 years jail term based on the offenses that she has been charged with. Let me start off with you. Yes, that's it. Lawyer Martin, people on this.
I should start.
Yes, please.
Okay. Yeah, so, right. Now, you see, the testing the soundness of the law, right? Mm-hmm. Let's go straight to the jugular. It's within the Attorney General's discretion to test. You see, I say so because, yes, and I know Honorable Penka comes strongly under Article 19, Clause 6. Myself, I've heard the Deputy Attorney General or that. That's Tuyaibua saying that no, 19, Clause 6 is clear and the rest. But let's get this distinction. You see, we are lawyers, but we are also participating in what? The governance of the country. So sometimes you just don't read the black and white letter and they say, oh, that's it. Sometimes you start a conversation. So the Attorney General decision to it's a good conversation test because
right,
yes, they have this look when such a thing happens, use the new law in sentencing at the time of sentencing the accused, just like this case. So meaning that there's a certain law at the time the crime is committed, and by the time the person is tried and convicted, the law is changed. The U.S. Sentencing Guidelines Commission has been saying that use the new law, and the courts have been rejecting it. So what I'm saying is that let's distinguish the arguments. I'm saying that when the AG goes on appeal, it's a conversation he's starting. It's all for the governance.
Okay.
If the court say, look, listen, we are sticking with this 19 Clause 6, like the way the U.S. courts have been doing, so be it. If somehow they find within that, no, okay, remember that this 19 Clause 6, we have kind of copied from the US and also the UK. Even in the UK, there's a case of R versus Dobson, where Lord Tracy, in sentencing the accused, was faced with such a similar case. R versus Dobson is quite a popular case on the internet. If you Google it, you'll find Dobson, right? Then listen to what she said in saying that she must use the old law, not the new one, like we're saying. Okay. And I know that we are part of the people who urge the Attorney General to test the law. It's testing, it's a conversation. So please, don't come at us that the law is too clear, don't try this, don't try this. Even OSP is going to test the law on the whether
public elections.
Public elections. So let's test. It's a conversation, and I don't know, maybe I have to repeat one thing. I'm at this table today. I'm part of this panel because I started testing laws, and a lot of them the Supreme Court agreed, and it's made our democracy better, made our rights for suspects and accused persons better. So don't worry, let him test. Okay, listen to what Lord Tracy had to say in sentencing the accused in R versus Dobson. She says, the law dictates that I must sentence you by reference to your age and maturity at the time of the crime. I cannot sentence you as the matured man you are now. In addition, I must sentence you in accordance with the practice in force before the coming into force of Schedule 21 of the Criminal Justice Act 2003, which now governs sentencing for murders. Okay? Then she goes on. In modern times, adults... No, let me just go to another part. I am also required by Schedule 22, paragraph 10A of the same act not to pass a sentence, not to pass a heavier penalty than would have been imposed before that act came into force. So you see the 1906, and so on and so on. Then she went on, then she complained that, yes, listen, that there was some discontent from the section of the public about this judgment, as justice was long delayed and blah, blah, I understand people are unhappy. Right. So these things have happened where others...
This one confirmed the
yes, that's what I'm saying. This one confirmed. But remember the argument we are saying. So Dobson confirms that 1906 is okay. And I'm saying in the same US, let's get it. They've been saying that for them, they'll go with the constitution that don't give a heavier penalty. But I'm saying that the Sentencing Guidelines Commission in the US has been saying use the new law. So that conversation, let's distinguish. Is that conversation the AG is going to start? Let him start it. Let's see how ours also pans out.
Mr. Kwenka.
Yes.
Mr. Kwenka, yes.
That conversation can only lead to one thing. That is if we have to do a constitutional amendment. Because if you look at the 1906, it is so clear that unless we go for an interpretation and then the events of Salah and Attorney General happen, that simple issue comes up and then the interpretation is given to it that nobody ever anticipated. Otherwise, the provision is clear. And immediately the sentencing came out and other people started expressing their opinion that we did the amendment and increased it to 15 years and etc. I just said that, look, people had forgotten about Article 19.6, which is very clear on this issue, that it is looked at the time the offense was actually committed. What was the sentencing regime at that particular moment, not at the time of sentence. You know, and so you have to distinguish the two. Because the time of sentence, the regime had changed. But the law says that you should give the punishment in accord with the regime at the time the offense was committed. And it was, if you look at it, it was between the period 2017, 15 onwards. Because our constitution is France on retroactive legislation. That you cannot take a decision today and say that it will take effect from yesterday. And it's very clear that we learned it from our history, that it has ever been used maliciously. So, for me, if we want to start a conversation, as you have said, nothing prevents us. But, I mean, to what extent are we going? Because she indicated or gave a reason why she had to apply the old law instead of the new law. If it were the new law, it's very clear that the sentencing regime should have been a minimum of 15 years and with a fine or
Let me seek a clarification. When we keep saying 15, are we saying that we accept that Aisha is a Ghanaian? Because it's 20 where you're a non-Ghanaian.
Non-Ghanaian, sorry. So 20 where you're non-Ghanaian, 15 for Ghanaian situation. So what we are actually putting across is very clear. For me, we don't need, even though I accept that we should trigger a conversation, but the question is to what end will that conversation take us to in the light of a clear provision in the Constitution that tells us what to do in circumstances like that. I did a matter last year, you know, and that one was about repeal, where a law has been repealed. The law was repealed like today, and the following day it took effect. Now, my client committed the offense earlier, and then he was charged under the new law. I went there, and the justices spoke that if you look at the State Proceedings Act, where there is no saving in the new act, you go under the State Proceedings Act, and then you come under the new law. And
Interpretation Act.
Yeah, the Interpretation Act. So that was what they applied.
Okay.
And I think that they got it right.
All right.
In my opinion. It's the same thing in this. 19.6 for me is very clear on the matter.
I see. Thank you. Mr. Bauer.
I'm not going to talk politics. Law. I'm just going to tell you exactly what I feel.
2 minutes.
What 2 minutes?
Yes.
I think that, look, the Attorney General is doing this just to save his face. You recall that just as part of this fight against Galamsey, the issue of Frimpong Boateng's report that came, and the opinion he gave, and the backlash he got. Particularly when there were clear evidence. For example, if you take the Erastus video, Saradonko's case, if you take the issues of the excavators, If you take even the issue of even they buy mining leases that they were selling, that they had evidence, the person even said that he had recordings and other things. Then you have a situation like this, and the man comes to write and says that I don't think that any of these things there's any evidence towards it. So I see these particular actions as a way of trying to just save his face. Look, let me tell you, this current government has failed when it comes to the issue of fighting against illegal mining. Indeed, now there's this level of audacity that they can even contemplate going to places like Kakum and other things, wanting to go there and make. You know this Akonta. Oh, you know this Akonta mining thing.
Explanation was offered to this.
No, you see this Akonta thing. I personally asked the Minerals Commission. I said, look, when this issue came up, you issued a statement saying that look, we have not given any mining lease to Akonta to mine in that. My next question to Martin Ayisi was that, have you gone to check as to whether actually there's no mining going on there? You know the answer he gave me. That does not fall under his jurisdiction because it is with Forestry Commission. This is exactly what he said. But I think that Martin, you will go. You are the people going.
Yeah, we've reported to the CID, and we still call up Madam Faustina.
So I mean, some of those things. That is. But I know you are going to close it. I'm begging you for some, just a minute to do something. That's a personal
30
thing.
seconds.
That's yes. We have what do you call it? One of my party executives, a former executive, a mother and other things, called Sheila Dongo, who passed just about 2 days ago. The death has been a blow to the whole constituency. Right. And I want to use this platform to extend. Yesterday, I tried calling the husband. Right. I couldn't get him. To extend my deepest condolences to the family. And hopefully we'll all be there to support the family.
Thank you. Professor Jampo.
Well, let me summarize everything that I've said. Number one, okay, a bit about this Aisha Huang thing. I think the reaction of the Attorney General suggests to me, or it should be a wake-up call on all of us for us to look at our sentencing regime and then the punishments that are given. We have to review them so that we ensure that those who run afoul of our laws, you come from your town, your country to come and destroy our environment, will have a stiffer sentencing and punishment for you. That's number one. Number two, Martin, we have an agenda. Help me to sue the special prosecutor. Yes. Number three, only in the lithium deal, only what is best is good for Ghana, not what is good enough. No politician can arrogate to himself the right to tell us what is in our interest. We know what is in our interest. We don't trust anybody in fighting our cause for us because these foreigners have what it takes to bribe everybody. And so we'll do our own fight. Like I said, they would have to murder all of us to be able to go into the ground.
Hopefully it doesn't get there. Professor Ramsford Jampo is a professor of political science at the University of Ghana, Legon. And then let me also put it out there that we have checked. And when you mentioned this earlier, Bauer, we have done our own independent checks. We cannot, and on this one, cannot independently confirm that the controller has enlisted party members on the government payroll. That is what we have to put on record. Joseph Kwenka is the former Deputy Attorney General and then also the NPP candidate for the Tempane constituency. Martin Pebu is private legal practitioner. Edward Bauer is a member of parliament for the Bongo constituency in this 8th parliament and a member of the Mines and Energy Committee of Parliament. On behalf of the rest of the team, I want to say thank you for joining us. Join us same time next week. Have a great weekend.